A democratic state like India must regulate the foreign influence. It's a necessity. But this should not come at the cost of weakening the civil society association and organizations. And that is the exact fear that has been arised because of FCRA amendment, and probably that is the reason that it has been deferred in Lok Sabha. Hello everyone, welcome to Vajiram and Ravi Flash News. My name is Shubhangi Singh, and in today's session we will be discussing that what exactly is FCRA, what is the amendment that is being proposed, and also what is the controversy around it. So let us begin with understanding that what exactly is Foreign Contribution Act. So when we talk about Foreign Contribution Act, this was enacted in 1976, and the whole idea of bringing this act was to regulate the foreign influence that is coming in form of investment, foreign influence that is coming in form of contribution. So this FCRA was enacted in 1976 and later it has been amended in 2010 and also further 3 amendments in 2016, 18 and 20 have taken place. Now the whole idea behind it is to ensure that if foreign funding is coming, contribution is coming, that needs to be regulated and to ensure that this funding should not harm our national interest or harm our sovereignty. This is the whole idea of this act. Now, how this is done, how this act was making sure that these objectives are achieved, this was done through mandatory registration and prior permission before the funding comes in. And the funds which are coming from outside our country, they were for very specific purposes such as cultural, economic, educational, social and religious. No matter what the funds are being used for, they would need a proper registration where the fund is going, and permission would also be required. Now, this very act is proposed to be amended again. It was tabled in Lok Sabha and as of now it stands deferred. Now, deferment happens because of controversy. Union government brought this FCRA Amendment Bill and they have also deferred the discussion of this bill. The reasons around it is the controversy. The controversy is related to the fact that there are allegations that this bill is being used to target NGOs and also minority institutions. And there is another angle of the controversy which talks about that this is related to Kerala Assembly elections which are due to happen this very month. Now let us try to understand first in detail about FCRA and then what exactly are the pros and cons around it. So when we are talking about Foreign Contribution Regulation Act, first we have to understand that what is the idea that the amendment has been brought in with. So the government thinks here that there are certain structural gaps which are present in the FCRA Act and that is why the amendment is required. Such as there is no clarity on how assets are handled. If there are penalties, they are absolutely inconsistent. There is no defined timeline for registration, renewal, etc. And also there is a lot of confusion around how suspension works out and how cancellation works out for the entities which are getting the funding. So government thinks that these structural gaps need to be addressed and that's why they have got the proper amendment bill. And they think this can be addressed through a uniform and also enforceable regulatory framework which will address all these structural gaps. Now to address all of this, government has got some new provision in the amendment bill. For example, there is a designated authority. Now this designated authority will be centrally responsible for all the management of funds and the assets which are present for the organization which are receiving the funding. The provisions are also talking about trigger conditions, in which situation the registration can get cancelled, when the registration has to be surrendered of that civil society organization, or it can be expired. So this registration and how it can work out, that has also been mentioned. Apart from that, there is a direct provision of asset management. That means government says that if there is suspension of the civil society organization, there will be a temporary takeover by the designated authority, and there is a permanent takeover that is also possible if NGO becomes defunct, or if the NGO or civil society organization, they do not restore their registration. Furthermore, there is a special provision for religious places that the character must be preserved of the whole objective for which it has been established. Now, when we look at these provisions, I am very sure you are also able to make out the fact that a lot in terms of power is being handed to this designated authority. They are not only the one who will manage the funds, they will also be looking into registration, who will also be taking over the assets, and that leads to centralization of power, which is a key controversial point here. And that is why this becomes controversial, because there is this risk of state overreach. There is this risk that NGOs would have to lose their assets because if they are not able to follow the procedure, and there is also a fear that this is one way of targeting the minorities. Now, government is saying that we want to make the structural gaps right, we want to fill that up. We want to address the security threats that are coming in form of funding and influencing our national interests. And they also are saying that we want to prevent misuse, which we are seeing in multiple cases in form of forced conversions. That is true. The intent of government, let's for a minute consider that's absolutely right. But I started with the statement that when we are talking about democratic state, yes, we need to control the foreign influence, but at the same time, it cannot come at the cost of diluting, weakening the civil society organization. So, as of now, this core debate is about national security, which is standing against civil society freedom. What do you think which is more important, or there should be a balanced trade-off? Because when we are talking about way forward, the most important thing that we would have to mention here would be a fine balance where there is no risk of state overreach. State stands as a facilitator, a regulator, but at the same time, NGOs are not threatened. Civil society organization, their purpose is not weakened and diluted further. Now, before moving towards the way forward, another political dimension that we need to discuss, because that has been in news, is the Kerala factor here. So, basically, this issue has gained a lot more traction, especially in Kerala, because Kerala is going to see assembly elections this month. Kerala has lump sum population around 3.34 crores, and when we look at this number, 61 lakh approximately are Christians based on 2011 census. We are yet to see the new census and the newer numbers around it. Now, this particular amendment is being heavily opposed by left in Congress, because they are saying this is going to target this 61 lakh Christians population, and that is why it is being heavily opposed, and it has also become an electoral issue apart from the key debate that we are talking about here. Now, in terms of way forward, as I said, the whole idea lies around the balancing approach where we ensure regulation, facilitation, but definitely not suppression. It is important that we have clear guidelines on asset takeover, there are proper judicial safeguards, there are provision of judicial reviews, and most importantly, the renewal process needs to be less cumbersome and most importantly transparent. And whatever is to be decided cannot be one-sided, cannot be forced. It needs to come with stakeholder consultation, especially amongst the all parties involved. Now, what are your thoughts on this? Let me know in the comment section. I'll be leaving you here with the prelims practice question. Let me know the answer in the comment section. That was all from my side. Thank you so much.